Hearing matter. But subject matter kindly was mentioning about a group 1 hearing matter for enlistment, deep level enlistment.
Mention will be listed, but I don't know when hearing matter will be.
But at least let it appear in the monthly subject to matters convenience so that it can be taken any deep level.
But I mentioned earlier, tomorrow it is expiring. Now the files have also been brought.
They could, I don't calculate.
May your lordships kindly, this is the 5th attempt, your lordship. I'm mentioning today is the 5th time it's expiring, tomorrow, your lordship.
Some files have not been able to be traced because of a lot of files being brought down from court 5 to the department, which is why the matters have not been appearing despite mentioning 5th, 6th or 7 times. So mention it. If it is there, it will definitely appear. There is no reason for withholding the file if the file is there, or withholding it from it being listed.
It is expiring,
Lordship,
your lordship.
Very well to be taken care of. Even if suppose it is not listed tomorrow, it is listed on Monday. To be taken care of. It can't be said that whatever has been done by the authorities illegally will not be undone.
Lordship, may I kindly mention, my lord, item number 127, 128, 129, 130, my lord. Lordship may remember last week, my lord, Mr. Banerjee also both mentioned, my lord. Now they have yesterday, my lord, gave the report, my lord, copy of the report, my lord. I am praying for, my lord, taking up the matter because, my lord, cash is not permissible.
Banerjee,
No, Mr. Obrodip, my.
Mr. Banerjee. I have already served him.
Yesterday, sir.
Will it appear next week? Because it
Monday, my lord, Monday, my lord. May I submit the slip, my lord, also?
What is the urgency, Mr.
My lord, urgency is that, my lord, cash seized, my lord, cash is not permissible and stock is, my lord. Monday, my lord, I am grateful, my lord.
Today's list, it is for extension of interim order. It has come under hearing.
अच्छा 399
399 गीता गणेश प्रभु.
এটা কাল के extension এ দিয়ে দিন.
It is tomorrow. The larger lordships may extend it tomorrow. It will. And 3 other matters for extension, as your lordship indicated, some files are not there.
Yes.
So I will again
mention it. You mention if it is available, then in that case matters will be listed tomorrow. As and when we are getting the files, matters are being listed. Because you see, thousands of files suddenly come from one court to the department. These people also cannot be blamed.
That is right.
Because time
some
is limited.
matters are coming also. Some matters are come. Yesterday also,
in that time only they have to sort out the files for daily listing also. Then those matters which have come, those will be taken care of. Even if they proceed.
399 lordships just tomorrow.
399 is there in the list, it will appear.
Great.
Your
Well,
lordship,
kindly allow me to mention a matter. While this is for inclusion in the daily list, the urgency is that the GST registration has been cancelled. So we are not able to apply in the portal for revocation of the cancellation. So this may be included in the list, my lord.
It's an urgent matter. Urgency
Yes.
is mentioned.
Yes, my lord, mentioned.
For extension of interim stay. It is expiring in the month of December 2025.
December is quite far. End of December.
End of December.
Please wait.
one more matter where
Mention the ground of urgency and then hand over.
and another matter is bank attachment.
Mention the ground, give it. देखुन दीदी urgency गुलो urgent matter है हमने दिया.
Malad, may I be permitted to mention one matter, your losses?
Yes, Mr. Sani.
Item number 404. Malad, I mentioned it earlier for inclusion. So ultimately, this has been included. Malad, the urgency is regard to admission. So, Malad, and I guess that this will not be ended over before your lordships. This will, whatever your lordships either way decide, it will go up to that. So, Malad, ultimately it has to be decided. If your lordships on the urgent basis do not take it, the entire matter will be infructuous. So, in the admission process, I just tell your lordships, whether in a school admission can be confined only to the boys when the school was initially sanctioned as or recognized as co-ed institution. Malad, it goes to...
When Mr. Sanal, when is the admission process going to
Malad, I tell your lordships, if your lordships go by this, obviously in the month of January, but your lordships will take some time to decide it, and either way it will go to the higher division bench. So, Malad, I want immediate decision so that it can be resolved. One petition has already been infructuous because Some of the students moved it, but it could not be heard at all. So if I lose this term session, your losses, this will also not achieve the same fate. So I beseech your losses, kindly take it up any day convenient to lordships in the coming week.
ঠিক আছে দিদি 404টা একবার কথা বলে আমরা একবার হিয়ারিং এর কোন একটা ডেট রেখে আমরা ওটা উপরে করি তো
Much,
very well,
much, much. So,
Last occasion also they were not.
Kenny, none appears for the petitioner. Full stop.
May it please, my lord. I am for the petitioner, my lord. Now, this petition, my lord, we have been enjoying interim order for quite some time, my lord, and we are ready for hearing, my lord. May I just place the first order whereby we have obtained the interim order, my lord,
Liken it.
and also the
this
last
matter-
order, my lord.
This matter is
may-
appearing under the
request, my
heading
lord, is filed.
extension of interim order upon the same being mentioned there.
My lord, on any
No
day.
fixing. It will appear in December monthly list, then we shall fix. Chalo.
My lord, my lord.
Next.
The hearing at
My
my
lord.
instance for extension of interim order. It was last extended on 28th of August 2025, passed in November 2023. It's expiring today. my lord.
My lord, I am for respondent number 2.
My lord, I am for respondent number 2.
My submission is that and they
My
are not interested in.
lord, I am for
pursuing the-
respondent number 2. I'm the with your
Not
lordship's
interested
permission.
in pursuing the hearing.
My lord, this matter has been
Learned friend is aware of what is submitted different judge.
In September, 3 times the matter came up for hearing before your court. Only once they have come and taken not today. Twice they have not appeared.
What? No,
And on the date of interim hearing.
But none of the orders say so. The orders say that interim order is extended.
Yes, my lord.
It has not been recorded that any time was sought for on their grounds.
But
That has
every
not been
time
recorded.
your lordship will see my name till Justice Shampa Sarkar's order of 30th of August 2024. Every time the extension was granted after a full-fledged hearing.
No,
And
my
in
lord.
fact, these statements should not be made in court. It's an aspersion on the council. Basic, if he wants to argue, let him. No one's shying away. When it came to the law, they wanted to run away and not argue. I was there in court. A question was put regarding applicability. None of them were put in a position to answer. After an affidavit in opposition was filed, they filed the supplementary. It was just on an issue of law. They scampered away. The court had put a query to them. What kind of submission is this? That we are running away, we are not interested in hearing?
My lord, may I make a submission?
Fixes it any day, my lord, I'll do it.
My lord, there has been 11 extensions in this case. My lord, affidavits have been exchanged. My humble submission before my lord is this: let the matter be fixed for hearing in the monthly list of December. If my lord is inclined to extend it, my lord, the around 580 flats are at the verge of getting disconnection of water. If you're the order which they have impugned order they have cited, if you kindly go for the paragraph number, page number 4 and 5 of that order, my lord, we have categorically mentioned that there is highlight of my lord. When he was making my submission, my lord, that is what my submission is, that there are 1100 flats and 580.
Any day.
You agree to a date, which date? I'll fix it.
My lord, because first the monthly list of December is coming, my lord.
That's not agreeing to a date. Again, he'll come before another judge and saying, I'm
no,
not.
No, my lord. But kindly fix a date.
I would want to do it here. It's whether it's just on a question of law, and I'm ready today also.
Can it be done today?
No,
my lord, I am actually right now in Delhi. My physical copies are. I am in Delhi right now. My physical copies are not with me, my lord. Kindly, if it can be appreciated, in the first week of December, my lord. First week of December.
Under the heading extension of interim order, upon it being mentioned, therefore, full stop. Heard the learned advocates appearing for the respective parties. Full stop. Parties agree that the matter should be listed for hearing in the combined monthly list of December 2025. Full stop. Since the interim order is subsisting and is to continue till the end of November 2025 now, till 28th of November 2025. The same is extended till the end of January 2026.
My lord, kindly make it December. We will conclude the hearing between it.
No, because before December, if unnecessarily it is not being concluded, hearing is for some reason not concluded, that is again extension.
My lord.
So instead of having a mini hearing, let us have a full-fledged hearing. Both of you can give a suggested date so that I can upgrade it. It cannot be there where it is in the monthly list of December. It is fairly at the top because of it being under the extension of interim order caption. So it will come in the hearing list. It will be at a place lower, much lower than where it is.
I'll just indicate. RERA, my learned friend, is appearing for the association. Their complaint before RERA. It's about applicability of RERA to the project. So RERA is the answering authority. Mr. Bihani was appearing for RERA.
He's not there.
He's not there. Mr. Bihani is not there for RERA anymore because there was some problem. I'm not panel. There was some panel change and all that.
RERA means
but RERA is the answering authority.
Respondent number one was not there even on the last.
Oh no, even on the last occasion. My lord friend is not the answering respondent.
You are appearing
my lord. Kindly go to para number 3 of their application, where we are an integral part of the hearing. They have mentioned it.
True. Very well. As agreed.
That is what I'm saying. We are the aggrieved persons. We are the aggrieved persons, my lord. And liberty, my lord, kindly a liberty be given to mention the case post the mentioning of
that liberty is always there.
My lord.
Till the end of January 2026, full stop, list this matter for hearing in the combined monthly list of December 2025 as agreed between the parties.
My lord.
311, who is appearing?
My lord, I am for the
My lord, I
petitioner.
appear for the petitioner, my lord. My lord, in
312.
this matter, I appear for the petitioner, my lord. I am led by learned senior advocate Mr. Shoktinath Mukherjee, my lord. My lord, it's my failure to make him prepare the brief within a very short period of time. He has been briefed very recently,
Want
my
an
lord. In that,
adjournment? You
my
want an
lord,
adjournment? When do
yes,
you
my
want?
lord. My lord, will kindly keep it after 3 weeks, my lord.
Very well. Item 11. Nakoto 311. 311 e likhun. Learned advocate appearing for the petitioner seeks an adjournment on the ground of unavailability of the learned senior counsel engaged in the matter, full stop. He prays for 3 weeks his time, full stop. As prayed for, list this matter for further consideration. On December 17, 2025, December 22, 2025, 22nd December.
Grateful, your lordship. Grateful.
Your Lordship, I pray for the pardon at the time of the item number 1. Pray for your pardon.
No, not a problem.
And I am for the petition. This matter.
I am for the private respondent number 8.
My lord, I am the owner in respect of some land. My lord, in front of my land, there is a land belongs to the government. My lord. The private respondent is occupying the government land. My lord. Without any permission, my lord, I have made a representation before the authority to take steps in accordance with law. My lord, page 28 is my representation. Till date, my lord, no step has been taken. My lord.
Yes, sir.
Lord, we have been staying there for a long time, my lord. I have been paying taxes over the said property. My lord, there is no occasion, no notice has
Who
been
is
served.
appearing
There is
for the
no
state?
question of unauthorized
Who is appearing for the state?
occupation.
Yes, state again.
Mr. Prashant Bihari Mahato. Prashant Bihari Mahato appeared last.
I'm passing it over. If you can contact him, bring him.
Yes.
Bring him so that an order can be passed in everybody's
Yes.
presence. Bring him. Pass over. Passed over.
My lord, I am for the petitioner, my lord. My lord, last occasion your lordship directed me to serve notice upon the respondents, my lord. I have
Sir,
served
appearing
notice.
for the respondent. Take your breath. Take your breath. Take your breath. Please take your seat. Normalize your breath and then speak. Yes. What is your matter? Take your breath, madam. Please take your seat. Take your breath.
My lord, last occasion matter was taken up by the Honorable Justice Biswajit Basu, my lord. His lordship directed me to file supplementary affidavit by annexing the document that the land in question is government land. I have affirmed the affidavit, my lord.
There is no direction in the last order. Last order is 12th of June 2025.
No, direction was passed by the Honorable Justice Biswajit Basu.
Yes,
my lord.
this order is there before me. I am reading from the order. It's not there in the order. No direction for filing supplementary. The order only says the matter is adjourned.
Parties to act on the suffer copy of this. On my list, yes, my lord.
There is no
But
direction for filing.
On that date, my lord, at the time of hearing, my lord,
What is
I
your
could-
case? You tell me that.
my lord, I have a house in my plot, my lord. My lord, in front of my plot, my lord, there is a government land. My lord, the private respondents, my lord, constructed a structure over the government land, which, my lord, obstructed my ingress and egress, my lord, as well as the drainage system of the locality, my lord. I made representation before the district magistrate, my lord. The district magistrate sitting tight over the matter without
Who is
taking any
appearing for the
steps, my
district
lord.
magistrate?
My lord, I have served.
Take the mic, sir. Please take the mic.
Hello, actually, I have no instruction right now. I am praying for adjournment next week.
Why?
I have not got the instruction, my lord.
Why haven't you got this writ petition was taken up on 12th June 2025 earlier. Somebody appeared.
Twice I have
You are
served
Mr. Joydeep Banerjee.
I am led by Jyoti Banji.
Where is he?
Whether Jyoti Banerjee is appearing in this matter, he goes to hospital because his mother is seriously injured by car. My lord, only not today, comes tomorrow.
This background you shouldn't take up. Let us take it up on next Thursday. I'll take it up again.
Twice I have served notice.
Very well, they are appearing.
Yes, ma'am.
An adjournment.
Then 14.
14, you are appearing?
No, ma'am.
None appears for the petitioner. Full stop. No accommodation is.
Is to direct me to serve, to give notice to the non-appearing respondent, my lord.
Yes.
My lord, I
am for the jail official.
my lord, I have given notice.
Affidavit of service.
Affidavit of service is stating. My lord, private respondent.
Affidavit of service file today be kept to the record. লিখে রাখবেন নালে আবার ভুলে যাবেন।
Unauthorized occupancy of government land. My
Yes.
lord, earlier the petitioner filed one writ petition. The Honorable High Court directed the SDO to hear the matter, giving opportunity to the parties. My lord, thereafter the SDO SDO heard and passed his order, my lord, which is page 23 P4. My
Page
lord,
23.
my lord,
Page 23.
page 23 P4. My lord, I am reading para 4. It appears from the BL and LRO report the opponent's house is situated by government land of plot number 104 measuring about so and so decimal and partly the royalty plot being number 105 measuring about so and so. My lord, thereafter he passed the order to demolish the 104 but not 105. And after passing such order, the petitioner made application under RTI Act, which is reply which is 25 annexure P5. In reference, may I read it, my lord?
So
In
there is an
reference,
order passed. There is an order passed.
My-
You have an appellate remedy. Why have you?
my
gone
lord,
before
I
the
am not
report?
challenging the order, only mere mistake. My lord, report given by the BL and LRO. BL and LRO says that it is a priority land. On the report, based on the report, SDO passed an order. My lord,
So
I
therefore this order has to be challenged.
my lord, I am not challenging, only may revisit he will revisit and
Who will
consider.
revisit? There has to be a provision for review for him to revisit. I cannot suo motu direct him. You go before the appellate authority. You
My
are
lord,
aggrieved by this order. then.
new cause of action, my lord. I am.
How can it be new cause of action?
My lord, it's a when.
This order is affecting you, isn't it?
My lord, this order is affecting me. I have enclosed here only to not to suppress the matter. But I have enclosed here. Since it is a government land, my lord, I am praying before your lordship to give a direction to the SDO. Consider this RTI whether it is government land or not. If it is government land, but he should take steps in accordance with
This
the
order
act.
was not passed against you. This order was not passed
Not
against you.
on the basis of my application, this order has been passed.
You are not satisfied with this order.
My lord, I am satisfied party.
Then what
My
more
lord,
do you want?
there is some mistake made by the BL and ARO. He says,
So why did you not point out then when the order was being passed?
my lord, that time of at that point of time, I have said this is a government land, but authority BL and LR said it's not a government land, it's a private land. Thereafter, I filed on RTI. On reply of the RTI, the authority says it's a government land.
Where is that? Show me.
My lord, it's a page 25, annexure P5. In reference to your RTI prayer dated 23rd 4 2025 under section so and so so and so. This is to inform the plot number 105 of Banpur Mauja jail number was acquired by LA case number so and so Tomluk area so and so so and so. Name of the awardee Tilottama Khada so and so. Compensation amount shares so and so.
Yes.
So my lord, I am praying only one direction may be given to revisit the same considering.
Revisit. I will not direct. I will not direct.
My lord, then considered to.
Yes.
It should be considered.
The report, my lord. May I?
Just a minute. I'll come to you. Wait.
You have passed the order, and yellow person has.
My lord, they have again constructed a building. I am showing for your lordship. I have enclosed.
So there is again this notice issued by them. You have seen this notice. They have taken action.
No, my lord, my lord, it's before this petition, 29/5/2025. My petition is.
My lord, if I may invite your lordship to page 10, the prayers. He probably wants enforcement of the order of eviction passed by the SDO.
Page 10.
Yes. Mandamus wish to commanding respondents, their agents and servants take steps against the private respondents forthwith to stop the illegal construction in the government land and remove the unauthorized construction done by the private respondents over the government land in accordance with.
Yes.
He probably wants enforcement of the order and not
Which
not the order.
Revisiting of the order, even I am not going to pass.
No,
where is your
I'm not praying.
Where is your representation? They will consider the representation in accordance with law, whatever it is.
My
where
lord.
is that?
Purbo Medinipur Jila Parishad here. My lord, I have given page 26, my lord.
26 is addressed to Jila Parishad. Jila Parishad is not going to initiate proceedings.
No, my lord.
The consideration is to be done by the subdivisional magistrate.
Subdivisional.
Then that is not there.
My lord, again, I shall make representation.
Where is shown? Page 23, the consideration has been done. May I take your lordship through this order? Page 23.
Yes.
It is an order passed by the subdivisional magistrate, in fact. And he says, where will not this grievances of the petitioners were taken note of. May I invite your lordship's attention to paragraph 3, the secretary Purbo Medinipur Jila Parishad.
submitted a report, it is so and so, where he says that block number 104 of so and so has not been leased out to anybody by Purbo Medinipur Jila Parishad till date. The private respondent said during the hearing that they had no house on the Jila Parishad place.
Where are you reading?
My lord, page 23, then the third paragraph. The secretary Purbo Medinipur Jila Parishad starts with these words.
Yes.
Submitted a report with a memo number so and so dated 16/4/2025, where he says that plot number 104 of Moja so and so Tomlu police station has not been leased out to anybody but by Purbo Medinipur Jila Parishad till date. The private respondent said during the hearing that they had no house on the Jila Parishad place. It appears from the BLRO report the opponent's house is situated partly on government land of plot number 104 measuring area of so and so decimal and partly on Rayati plot being number 105.
That is where he joins issues. Now
Yes.
stopping here, come to page 25.
Yes.
Page 25 is an RTI reply that has been given to the petitioner, where it has been informed that plot number 105 is an acquired land.
Yes.
So it's a government land. That is what his contention
No,
is.
105 is
So
not
he
right.
says that this 105 partly Rayati is incorrect.
So
It is acquired fully.
therefore, if he is so aggrieved, then appeal as has been observed by your lordships quite rightly. But he has not prayed for that. He has prayed for eviction and demolition of construction from 104. So that both could not be prayed at the same time. He could have prayed for appeal before the appellate authority. He has not done that. The period prescribed by the act is over.
This order was communicated to you also, isn't it? Or not?
This order is communicated to all the parties. Secretary Purbo Medinipur Jila Parishad Block Land and Land Reforms Officer.
How did you get notice of the order?
It was at these instances.
You are Vivekananda Das.
Malad.
Yes.
He came to court, directions were passed thereafter.
The order was served upon you.
Malad.
So you are a person aggrieved by the order. You prefer appeal in accordance with law. How can I direct revisiting the order at this stage?
Malad, Premati. Malad,
The kind constraint has.
Malad, I shall make a
There is no
representation to the
where is that? There is no representation to which I can direct.
Malad, kindly direct me to.
Why? I will give you everything from the writ court.
Malad,
You will not make
Malad,
representation. You should have made a
I am
representation.
praying. I shall make a representation to the SDO in respect of the
It is up to
105.
you. Whatever you want to do, I will not give any liberty. Don't expect that. The petitioner has prayed for issuance of a writ of mandamus. Command
Yes.
During pendency of the writ petition, the BLRO has already inspected the site, my lord. So far as my inspection.
No, if you get a hearing before the subdivisional magistrate, he'll give you a hearing and dispose of. Because in any case, I will not decide that. It will be decided by the authority. लिखे नहीं, all the parties. The writ petition.
petitioner, affidavit of service.
But I am appearing on behalf of the private respondent number 7, 8, and 9.
State. But affidavit of service I have already submitted. And my lord, the petitioner, my lord, is the premises holder, being plot number 839, under Mouja Kaktia. And my lord, in front of the petitioner's premises is, my lord, there is a khal. My lord, the irrigation and waterways department. And my lord, that part, my lord, which is ingress and egress of the petitioner, my lord, is obstructed by way of constructing the Paka structure. And therefore, my lord, the petitioner's premises is blocked by that Paka structure, and petitioners made a complaint before the subdivisional magistrate, my lord, Tomluk.
It's
My
a
lord,
government land according to you.
my
Which
lord,
He's occupying a government land.
yes, ma'am. Irrigation and waterways department's land. And my lord, therefore, the petitioner made a complaint before the subdivisional magistrate, my lord, Purvo Midnapur, Tomluk. My lord, that is annexure.
Let the representation be considered by them. He will hear you also, because I cannot decide this here. It cannot be decided by way of affidavits also.
Lord, I have one new submission. My lord, in the same Mouja, my learned friend filed several writ petitions. And my lord, in one of the writ petition, my lord, the court passed that type of order. I preferred an appeal before the division bench.
No.
Division bench inquired it. I bring the copy of the order also. And my lord, the deed, sale deed, and other documents have to be checked out. Because I believe, my lord, all the documents are not genuine. Number one. Number two, my lord, the private respondents are residing in the said plot for last 40 to 60 years. Now, my lord, some land grabbers came and they are showing one deed, and my lord, file one writ petition, obtain the order from the
Give me the
court.
order of the division.
Yes, my lord. And the report also, I am handing over both of.
Didi, okay, Didi.
ওই দেবাংশুদের ঘরে
সেইটা
Yes,
সেটা মৌজা,
শ্রীপুর মৌজা,
কি মৌজা?
এই তো শ্রীপুর।
My lord, purely irrelevant, my lord, submission.
Okay.
It is a Mouja, my lord.
Please wait, please wait.
Mouja Kaktia.
Please wait. So this appeal is still pending.
Yes, my lord.
No, it is separate Mouja, my lord.
And
Not this Mouja. It is a Tomluk, and that is a Ghatal subdivision. And it is Tomluk subdivision.
And my lord, I have the another
What submission my learned friend is submitting
and
before your
my lord,
lordship,
I
I
have
do
the
not
second
understand.
submission, my lord. তোমার কাছে বই আছে?
বই আমার
Kindly have a look into section 3 of the West Bengal Public Land Eviction of Unauthorized Occupants Act.
Yes.
I have
completely
only
vague
one copy.
submission.
I have.
Yes. My lord, kindly have a look into section 3.
Yes.
If in respect of any public land, the collector is of opinion, my lord, kindly pause a moment. The collector is of opinion, and upon application made by an officer of the owner of the public land, authorized in this behalf by such owner, or upon information received otherwise, that the public land is in the unauthorized occupation of any person or persons, the collector shall issue a notice in such form and containing such particulars as may be prescribed, calling upon all persons concerned to show cause before such date, not being less than 15 days after the date of notice, as may specified in the notice. Why an order under such and such subsection 1 of section 4 should not be made and shall cause it to be served in the manner referred to in subsection 2 intimation of the date so specified shall be given to the owner of the public land. Lord, if the private respondents are erecting the building, they are residing there for last 40 to 50 years. Section 3 clearly prescribes that the owner of the public land is the collector or SDO. Whether there is any objection.
No, Mr. Dalapati, you are missing another part.
Yes, my lord.
It can be on the application made by the owner or information received otherwise.
Yes.
In that, anybody else can make an application that will constitute information received
Yes, ma'am.
otherwise. So anybody from the public also can inform that, see, this is government land, because government land is everybody's land.
Yes.
Government is everybody's government. It's democracy. It is your government, my government. So government's land is everybody's property. So I have that way a right of ownership over that. Hence, this this clause will have to be read in such a manner that it gives wide, it has an expansive view where anybody can go and inform the public authority concerned that this land is under occupation, unauthorized occupation of a person. You please take steps, because mere information is not going to amount to eviction. He will have to conduct the relevant inquiry, come to a conclusion that the person concerned who has been complained against is in unauthorized occupation, and then pass an order.
I got your lordship's point.
Lord, because he has no right is going to be conferred upon anybody, neither anybody's right is being taken away by directing consideration of representation. Now, that was a case where the person concerned had come up and misrepresented facts before the case, saying that he is the owner. Now, if this is the case here also, then in that case, that takes a different course altogether, because although even if you are not an owner, in terms of this you can apply, but you have obtained an order showing yourself to be the owner, that is sort of misrepresentation. Court may recall the order because it is an order obtained by fraud. Yes. That is one line of going to it. So here in this case, whether such is the case or not, we don't know. Because he has apparently brought on record a title deed, which,
you know, in the earlier writ petition also, my lord, they are abusing the process
But
of law.
why my learned
Who will say
my lord is
that
submitting in this
the
way, in this
title is
fashion, my lord, I
proper?
do not.
wait, let him
In the writ court, my lord, writ court cannot say that he has the title over their
Right,
property
right.
and cannot
We
adjust the title
we
deed.
cannot.
And my lord, therefore, the collector or the authorized persons of the collector have
Who
the.
is appearing for the state?
I have served the
You
copy.
serve another notice on the state. Let the
I
state
served the copy also.
serve another copy.
Only my lord notice.
Yes, I will
There also that nobody is appearing for the state. It's the same is for Jela Police.
Yes, I have for Jela Police.
But state is the main part.
Yes, state is the main part. So I am like a petitioner in the proceeding. The only difficulty is, but I'll tell your lordship, is your lordship's last order.
Yes. When has it been fixed? State was there on the last occasion.
Yes. It was adjourned till the disposal of this request. On the last occasion, my lord, SDO passed an order disposing of the adjourning the proceeding till the disposal of this request.
Then you have time.
But your lordship's order only said that the matter.
So they have given a date.
Yes.
They have given a date that it will appear after the writ petition is disposed of. That is what he's saying.
Yes, but that was not your lordship's intention. Your lordship only could not.
Very well. So in any case, if the date is not there tomorrow.
Blood, the order is this.
No, I am not on that. But my point is, the matter has to be taken up by the officer.
They will take it. They will take it up.
Otherwise, just mere filing of a writ petition will not amount to stay of the.
It won't. It won't.
So that is the likely result.
No, the last order
because this writ petition is
the officer.
It says not you inform Mr. Dhar. Let him come. You please proceed.
Yes. I think this is better.
Because in any case, unless the state comes, I'll not be in a position to
Yes,
pass
I
an
am
order.
saying, Lord.
So even if the hearing goes today,
for that the proceedings cannot be adjourned finally.
no. If I am hearing the writ petition, I am in the midst of hearing. I'll conclude hearing, and that authority will also continue. That I will ensure that doesn't happen.
That will
also not happen.
Of the party should not be just to have.
It will have to be the intention of the
not
court
my
to see
intention,
that
Mr.
justice is rendered.
Yes,
Merely
of
because
course.
they are proceeding, therefore I should stop. That also cannot be.
No.
So that also that impression also should not go that I will act according to their convenience.
No, your lordship.
So if I am hearing a matter, I am to conclude the hearing.
Yes.
If I am to conclude the hearing, they will have to stop their hands. I can pass that order also. I pass that order only because of convenience, so that there is no stay.
Yes.
Now, if this kind of attitude is there, that no, I will pass it, although you go on proceeding with the hearing.
That is not the intention.
Very well,
The
that is why I said.
SDO has already said it is adjourned sine die.
No,
Very well.
What SDO has said.
SDO has said he has done the right thing. He has done the right thing.
But we will have to also proceed.
Who is not proceeding? The parties have to be there before me. What is the use of proceeding peacefully?
I am agreeing to proceed. Let the matter keep on.
Please proceed.
I'll proceed. No issues. But again, Milord, what will happen, Milord, in the absence of Mr. Thor or state respondent, your lordship has to adjourn the matter. This is the fact. Wastage of court time.
We can inform Mr. Thor.
Please inform
Yes,
so that he can come. No, it is chulchi.
Milord, this is a matter, Milord. May I just recapitulate, Milord? An agreement for lease was excluded by the Milord Murshidabad Jila Parishad in favor of the writ petition. This agreement for lease was, Milord, in the year of 2004 for a period of 21 years. There are certain terms and conditions are there. In the agreement for lease, Milord, there is a clause for arbitration. And the district magistrate was named as an arbitrator in the Milord lease deed itself. Now, Milord, there are some dispute between the Milord parties, Milord, that there are several proceedings are pending. Now, ultimately, Milord, the Jila Parishad, Milord, terminated the lease. Even after termination, Milord, I paid rent, Jila Parishad duly accepted the rent. And it is going on. Subsequently, Milord, I filed a suit challenging the Milord notice of termination and the attempt of the Jila Parishad to put the property in auction. These two things were challenged by filing a suit before the Milord Civil Court at Bono. Initially, Milord Civil Court passed an order of injunction. This injunction order was continuing for some time. And this injunction order was passed Milord 10th of July 2024. Now, Milord, Jila Parishad.
Yes, I remember. Thereafter an appeal.
Thereafter an appeal.
Order
set aside. The matter was remanded to the Milord arbitrator. Entire suit proceedings were referred to the arbitrator. Now, Milord, arbitrator was not named just because the court did not have the jurisdiction on that particular point of time. Thereafter, Milord, I gave a notice under section 21 for appointment of arbitrator. Now, they did not act. Thereafter, I filed a section 9 application before the Milord Commercial Court at Milord Asansol. In Commercial Court, Milord passed an order of injunction directing the parties to maintain status quo in respect of the property in question. Now, Milord, in the meantime, the order of Milord, what happened? So far as Milord, this
proceeding is concerned, this proceeding had been initiated by the SDO at the behest of district magistrate. Now, district magistrate, I can show to you, Lordship, district magistrate is the administrative head of the Jilla Parishad. Now, what district magistrate has done, district magistrate requested the additional district magistrate to take necessary steps for the purpose of initiating proceeding under the West Bengal Land, Public Land, Eviction of Unauthorized Occupant Act 1960. Now, this proceeding had been initiated by the SDO at the dictation of the district magistrate, and the notice was served upon me asking me to give focus to the proposed eviction proceedings. Now, by that time, I approached the civil court. Civil court passed an order of injunction, and the civil court order of injunction is still subsisting, and it is operating till at least till 15th of December 2025. Now, so far as this proceeding is concerned, I have challenged this proceeding. There are threefold grounds. First ground is that SDO is proceeding on dictation of the district magistrate. Now, whenever the statutory authority is proceeding on the dictation of higher authority,
Yes, I have noted.
Yes.
You had said number one is that SDO is acting at the command.
Yes.
DM is the appellate authority.
Yes.
Then SDO is acting with a premeditated mind.
Yes.
And you cannot be termed as an unauthorized
Unauthorized
occupant. These were the points that you made.
These are the points I have already submitted. Now, so far as notice is concerned, I am saying this notice is absolutely without jurisdiction. As because it is the Jilla Parishad. Jilla Parishad says that the arbitration clause is there. So my suit had gone. Thereafter, matter has been referred to the arbitration. Now till now, my section 11 application is pending. So I also filed an application under section 11 for appointment of arbitrator. In that proceeding, Mr. Sen appeared. First day, asked for time to file a opposition. On the last occasion, also, an extension was granted, and matter is fixed on 9th of December. Now, Jilla Parishad on one hand, saying the arbitration clause is there, the matter should be referred to the arbitrator. My suit gone. Now, Jilla Parishad, what they are trying to do, with the help of the state machineries, they are trying to evict me. Now, he is having the state machinery with him. There is no doubt about that. Now, you cannot take the state machineries just to evict me by throwing all the procedures of law. Now, so far as SDO is concerned, I will just show you, Lordship, the way.
What is the position? If there is an arbitration clause, does that mean that the application of the act is ousted?
No, there are conflicted judgments. Now, one judgment is saying that both the proceedings can run together. There is no doubt. Now, here your Lordship has to find out whether SDO in such situation can proceed with the matter. I am not saying the arbitration clause is there that they cannot take steps under section 62. But the way SDO is proceeding, the way state administration are being doing all these things for evicting me, this is absolutely 100% unclear.
But if that is the point, I can suggest a via media, subject to your Lordship and my learned friend, without this should not be taken as a concession on any point. My learned friend's now grievance, as I have just now heard, is mainly against this particular SDO, because he is saying he is acting at the instance of the DM. If that is the case, then without prejudice to the rights and contentions of the parties, Lordship can delegate the proceeding to some other SDO within the district for carrying out the proceedings in accordance with law. I can make that concession if it is his stand that this is an SDO who is biased. He is being made to act.
That will not be fair, because then the SDO needs to be heard. It will be a
I know that. I said just to prevent the via media. Otherwise, because my learned friend has
then the SDO has to be made party.
I understand. I understand.
Based on
cut
the matter, sir. Based doctor. Your Lordship, arbitration. Section 11 is there. Let arbitrator decide all this.
There I have a point of view. There, my submission.
That is more important.
More important.
That
I
is
thought
more important as to whether there is a conflict.
Yes.
If there is an area of conflict.
Yes.
And whether one outs the other.
More focused on
because
that.
the earlier Vidya Drolia's regime.
Vidya Droli has clarified it.
Yes. So
that if it is covered by a special statute, then the arbitration cannot take place.
Even if there are judgments, that even if it is covered by a special statute.
But this much I am ready to argue. That arbitration.
This is the important point, most important
subject matter of the property in question. This is the subject matter of the property. Well, arbitrator will not, what arbitrator, he will protect the subject matter of the property. Subject matter of the property he will protect. Well, this is the subject matter. Now, well, he is trying to take my property by way of by invoking this provision of law. Now, well, arbitration goes. Arbitration
But I
goes.
told they are not here. They have gone to LRTT. So can we come back tomorrow? In that
Well, tomorrow, next Thursday, you put
No,
it
I'll
for
take this on Thursdays
Thursday,
only because the bigger determination is of group 4 matters.
there are other things.
and if as a special case, well, the entire proceeding has been solved.
Next week, I'm taking it every
Next
week.
week, I'll-
Every week.
Priority to achar ko priority.
Last week only we could have proceeded if there was not that in between thing.
But that I say, my lord, if they are agreeable, it can go to another SDO. The
You
proceedings.
can think of it.
No, Milord, it cannot be. Milord, can you consider
Because this one point will be the
I-
most
I-
important
I-
point.
My learned friend on the last
I
opinion
know.
argued entirely on that point that the SDO is that dictated. He was not on the point of arbitration.
Milord, notice.
So if that is his main grievance,
No, I have
let it go to
several
another-
other grievances.
another
First
officer.
grievance,
I have nothing to
other
say.
grievance is, Milord, the ascertainment of the plot. Milord, SDO is also in Dalainama whether this plot belongs to the Jala Parishad or not. SDO directed the BLR to file. No, there are so lot of things are there. Milord, let's see the next. Read code can decide it. 100% can decide.
Court decide whether the property
I
is
will not. Factual things I will
Factual,
not.
I will not go by factual aspect. I
the
will
order
meditate on law point.
challenge if my learned friend
Only
can show
jurisdictional
that it's not a
Jurisdictional
government.
issue. I'll
So whether it is a government land or not, that the writ code in a show stage cannot go in.
I am not going to say
That may be
So cause notice stays, only thing which is important is
jurisdiction.
jurisdiction.
is an assumption of jurisdiction.
Yes.
Jurisdiction.
Yes.
That,
I will make my argument only on
cause
that.
notice does not give rise to cause of action.
No, I will not
Only
make any
thing
argument.
is, if the person who has issued the show cause notice has jurisdiction,
Or not.
Yes.
I'll wash my hands off.
Yes, absolutely.
If it is shown that yes, it is absolutely without jurisdiction or palpably
Illegal, malafide,
then in that case, yes.
all these things I can put in.
Then this.
So I made the suggestion because the last day's argument.
Yes.
Entirely SDO was dictated. I don't want to go
No,
into
Milord,
it.
my other argument is this, Milord, subject matter of the arbitration, they are trying to take away by using, Milord, state machinery. This would be my
No,
next
that is not
and
the
this
point.
is
Is the government land or not?
Ah,
That is the important
the
thing.
thing. This is the
I'll try and give 2 days for public premises unauthorized occupants act matter.
But even a half more day, well, that will also.
This I have not indicated anything. I have said public premises occupants act. Once it is finished, I'll go to group 4.
So then it can
So it can continue even today for the entirety of the day. But the problem is, but then he can finish it today.
Yes, I don't have any problem.
You can finish it
Even I
today.
can make my submission.
let Milord, state comes. Milord, the next Thursday, Milord.
State actually has practical.
No. State is the main.
No, but arbitration clause which will supersede or not, that I will also have to
Let me
satisfy.
come back.
Yes.
Let me also come back.
But we can use the time. But, I can do.
I can also use the time, Milord. Kindly take next Thursday. I'll pick up. So far as that.
Thursday, there was in the grey versions.
Today, well, the matter has been adjourned. That is why my learned friend does not want to take up the matter. I think we could have proceeded today.
Next Thursday.
Mr. Tiwari, if you are ready, let us
So
proceed.
far
Take
as
time.
this point is concerned, Milord, let me also make some research also. I have some judgment, but let me come back on next Thursday. Next Thursday, I'll make.
Then we can. Heard Mr. Tiwari, learned senior advocate.
I am for the petitioner, affidavit of service taken on record, my lord. Lord, the petitioner is the premises holder being plot number 839, my lord, which stands, my lord, just by the side of the canal. And my lord, therefore, the petitioner's frontage is a canal part, and it is used by the petitioner as his ingress and egress. But my lord, the private respondent has constructed the Paka structure, my lord, and blocked the ingress and egress. Therefore, the petitioner made, my lord, an application before the subdivisional magistrate, my lord, HON'BLE, my lord, which is at page 21, annexure P4, my lord, to remove the unauthorized encroachment from the public property. And my lord, he did not, my lord, consider this, and therefore, my lord, the petitioner come before your lordship for necessary direction to consider the representation in terms of section 3 and 4, and my lord, remove the structure from the ingress and egress.
Consider and dispose of.
Yes, my lord. The representative can be disposed of within certain time, my lord. If it is found after inquiry that there is encroachment, this step will be taken.
Affidavit of service filed
I am appearing for the private respondent. And I have served all the respondents and service has been effective.
Yes.
This petition has been filed challenging inaction on the part of the subdivisional officer to initiate proceedings for removal of construction on the government land, my lord. And this is second round litigation, my lord. First round litigation, my lord, there is a direction to make an application before the subdivisional officer, and I have done, but no steps have been taken. I kindly come to page 38. Page 38, my lord, observation of the court, coordinate bench, my lord.
Yes.
In view of the same, the petitioners are granted liberty to file an appropriate application representation before the concerned SDO. In the event the same is made within 2 weeks from the date of concerned SDO, shall consider the application in accordance with law, and upon hearing the interested parties as expedient as possible, preferably within 8 weeks from the date of making communication. I have submitted the application on 11th February 25, but no steps have been taken. And direct the sub-divisional officer to initiate proceedings. This is a big construction, my lord, on the government land.
Who is appearing for the government? Who is appearing for the SDU?
My lord, I am appearing on behalf of the SDU.
Why is the order not been complied with?
My lord, I
28 January 2025 order.
See, my lord, I have sought for instruction. No instruction is forthcoming. Your lordship can make it time frame.
Why time frame? Why should this not be complied with? There is an order of this court. Why should he take it lightly?
I don't know, my lord. I've sought for instruction till now. My lord, no instruction.
Direct the
Yes,
authority
authority
to,
to make
initiate
it time frame, my lord.
This application I have made in the month of February on the basis of court's order. No steps have been taken. I kindly see the photographs. Aspects 27. From the very beginning of the construction, I am raising objection.
Where is your representation? Which page?
Page 39.
Page 30.
Annexed P7.
How have you served it upon the SDU?
Yes, that is also based.
Hand service, where do I get? There is no seal.
Questionable, my lord. There is no seal.
Where is the seal? Where is the stamp?
My copy is also no seal.
The original receipt is there. That maybe my lord has not.
My copy is also no seal.
There is an original receipt. You file a report. What has happened?
Or your lordship kindly not making it pending. Your lordship kindly make it time bound. And
No, but I must see whether this has been served or not. And what steps have you taken?
Yes, yes.
What step have you taken in terms of this order?
If my lord they now not served, then that is something different.
No, I have served, madam. This is original.
So let him file a report on what has happened, because there is a seal. You cannot say that not served.
Yes.
Who has received it?
There is no question of my lord misleading. This is a signature also, my lord, with date.
Let him file a report why he has not taken action.
May I submit one thing, Miller? The lands where construction is starting, Miller, is a private land.
No.
Both the plots are private land, as mentioned in the.
Very well, that is not being decided here. That will be decided by the SB. It is a private land. He will not initiate proceedings. But he should act on the basis of the order of court.
And the copy of the record of right.
The petitioner is aggrieved by
320 minute, I am for the state minute.
But I beg to appear for the petitioner, my lord. Your lordship kindly takes up the Your lordship kindly takes up the last order dated 20.
That is right. I had directed on the last occasion.
Yes, your lordship.
Take instructions.
They have
Filed the appeal.
Yes, 20th November.
Lord, with regard to that, on the last question, your lordship had directed the learned advocate appearing for the state response to ascertain whether we have filed an appeal or not before the appellate authority. My lord. Yes, my lord, we filed an appeal. Yes, the cause seal of the.
So why is the district magistrate not considering the applicant their prayer for interim stay?
No,
They have not filed any separate application.
Not required. They have made a prayer for interim stay in the appeal itself. In the appeal, they have made a prayer for interim stay. So in the meantime, you execute the order.
My submission is we are filing a appeal since 2015.
This will not do. You don't
I
read
have
the papers.
filed several writ petitions in all the
Please
orders.
come to page 42. Please come to page 42.
Yes.
What is prayer E before the district magistrate? He ought to have considered this prayer. He will not consider the prayer. Whether he will reject it or allow it is a different thing. But he should consider it.
But humble submission.
He should not consider the prayer.
Should have.
Then
But no,
that is the only issue.
But
that is the only issue.
Kindly see the prayer in the writ petition.
I am not considered about the prayer. The prayer is this. Whether he should consider the
No,
prayer
prayer is
or
not that. Kindly see prayer is not that.
Hearing notice there. Yes.
Prayer A.
Yes.
To set aside the letter dated 14.
Yes.
October 2015.
Yes, because this letter dated such and such is for implementation of the order while
Yes,
appeal is
Lord.
pending and prayer for stay is pending. You have not considered the prayer, you will demolish.
That letter is not annexed here below.
Who said it is?
Yes,
not?
my lord, it's annexed at page
Last time it
46.
was placed, you were not there.
Page 46. Limited period with fixed period.
Yes,
And
that was
adjourn the matter for that period and limited.
No question of adjournment. The district magistrate shall consider the prayer for stay and dispose of.
I'm not till the matter is disposed before the appellate authority, my lord, stay of operation of the letter dated 14th of October, my lord. Time limit can be given.
Yes, definitely.
And my lord, to that aspect, my lord, if that not be done, that's why my humble prayer, can adjourn the matter for limited period, so that
unnecessarily why will it not be done? If it is there is direction by the court, they will do it.
For limited.
Yes, limited period. You are appearing for the bazaar. You are appearing for.
No, I'm for the sufferer. That is response number 10. I'm the sufferer since 2015. And my several lead petitions are filed in all the lead petitions.
Well, there is a prayer
it is
for
confirmed
stay.
that the encouragement is done. That is my kindly record. DM will not say that yes, encouragement is allowed. That is not there. But
if he is considering, his appeal will become infructuous.
Should be concluded.
Appeal will become infructuous otherwise. This writ petition
because I have a bench at 3. Tomorrow will be specially assigned day. Monday we can have it. Not today, for Monday. It's the same list every day. Same list. My list is everyday monthly list.
Grateful, Your Lordship.
And Monday is also supplementary list. For what? What do you want?
I am an importer of sewing machines and I have been importing sewing machines since 2010. The core, the foundation of this instrument in this matter is that I am being exempted to pay the countervailing duty at the rate of 1% instead of 12.5% in terms of the exemption notification 01 of 2011. But I was constrained to pay 12.5% since 2011 till 2017. So I am also squarely covered by all the benefits of the SRF certificate. I am also squarely covered by that. I have given multiple representation for the issue of my refund, but there is no reply which I have received.
To consider his representation, dispose it off in accordance with law.
My lord.
If you want to give him, give him. Don't want to give him the reasons why you don't want to give him, so that he can come up.
I will not.
Don't keep it pending. Yes.
My lord keeps kindly grants like around 6 weeks time for consideration, and
it has already been pending for a substantial period of time before.
Yes, my lord.
Isn't it?
Let us kindly have page 57 to 69. These are my representation.
57 filed in 2023.
Yes, ma'am.
Then
last page
starting from page number 66 was of 23 June 2024.
This is the last representation, my lord. So maybe
the
that
first one is at 57.
Yes, ma'am. 57.
This is 2023.
Yes, ma'am.
So it's more than 1 year now. 1.5 years.
Yes, my lord. Maybe the last representation dated 26/6/2024 may be considered, and within 4 weeks, an order can be passed.
Affidavit of service filed today be kept with the records. Full stop. The petitioner
Well, a notice is incumbent on me, my lord. I am supposed to get a 15 days timeline for payment of the dues. That is my first contention, my lord. And second contention is, if my lord use the order and the recovery amount made, there is no relationship between them. I am unable to.
Has any notice for recovery
No,
proceedings?
there is no
been served?
instruction to this. But question is, my lord, 2016. But today, whatever remedy, my lord, if it is at best a irregularity. Irregularity, it's not an illegality. My lord, there has to be a difference between irregularity and illegality. This is at best an irregularity. My lord, if today it should be an empty formality. There is no appeal from the last 9 years.
But the statute says that you have
Well,
to serve
they
an
could
notice.
at best be irregular. Well, it will be an empty formality. I give a notice. What he will say?
No, my lord.
Because the assessment is being confirmed in 2016. Appeal he has
He is
to.
also right. If he suppose he gives a notice
Yes, my
that
lord.
I want to recover the amount,
Yes, my lord. I would.
you will have to pay.
No, my lord. I could appear for the SOD. I could apply for the SOD. It is an opportunity given by the government.
SOD means what?
The settlement of dispute scheme, my lord, which is given wherein
Which schemes? Tell me.
Settlement of
No. So there are schemes. 2016.
Scheme, is there any scheme pending at the time?
It's pending or something.
My knowledge is entry tax schemes are pending. It
No,
was
except for the VAT schemes are pending.
today the question is he is aware. He has filed an appeal. Thereafter, he has not taken any steps. The liability is there, but there was no stay also ever.
But my lord,
There was no stay. The liability was crystallized the moment the appeal was filed. Thereafter, I give him a notice or not give him a notice, SOD, whatever manner, he had to take steps. He had to take steps.
No, but even then, suppose he doesn't take steps. If there is a provision in law, how
But
can you
which
bypass?
provision he is relying on?
I just.
Which
Section
that-
52, my lord, section 52. And also the
আমাদের বইটা কোথায় না?
Section
on the third page, my lord. Issue of notice. I read the heading, rules regulating the procedure for recovery of tax, late fee, penalty and interest. So on section on supplement 2, where a certificate has been received by the TRO from the requiring officer for the recovery of the areas of tax, penalty and late fee or interest under this rules, the tax recovery officer shall cause to be served upon the defaulter a notice required the defaulter to pay the amount specified in the certificate within 15 days from the date of service of the notice, and intimating that in default steps shall be taken.
whether this notice has been served or
No,
not,
my lord.
Mr. Chakraborty.
We have not.
Because my lord, whatever address was available from the instruction, it would appear, my lord, that
No, this instruction is silent on this notice.
notice is silent, but whatever communication was sent, he has been found to be absent. Whatever communication.
But whether this was sent, if it can show that it was served, the matter ends there. Then in that case, he has no case.
Well, I'll come back with this. Well, I had asked them, but
My lord, that actually
Ask for a specific information whether this or this has been served or not.
and my lord, we also I think consider the fact that if an appeal is being ordered in 2000
Sir, if notice has been served,
Yes,
they are able to show that, you have no case then.
right.
You don't have an appeal. Your writ petition is based on the fact that there is
Yes,
an
sir.
appeal pending.
Yes.
Now you are unaware of your own appeal having been dismissed.
Yes.
And that too long back in 2016. So today you can make, whether you can make a meal of this at all or not is something which is very questionable.
Yes, my lord.
You cannot just pay lip service to the statute. That yes, there is a statute which says that notice should be served on me. So for 100 years, I have basked in the glory of not having pursued my appeal. Now, once the appeal is also dismissed, I have not taken any step against the appellate order also. I have allowed the demand to be confirmed. Everything is finalized. Then also I want a notice to be served on me. This, I don't think will be a very nice situation.
difficulty is the officers also not getting access to the record. 2016 dismissal. 2016, even 9 years have passed.
Because then I'll have to decide this and say that no, in such cases, non-service of notice may not be fatal. Because this is a telltale case of abject negligence on the part of the SSE also. You cannot suddenly turn out because until the shoe pinched,
No, my lord.
you did not wake up from slumber.
No, my lord. I would
You
just like to raise another
woke up
argument,
from
my lord.
slumber only when your account was attached and
Yes, my lord.
you lost some money.
My lord, but here I would also like to say that since 2016, recovery would have to be made and made in 2016, my lord.
Very well.
They had
Is it so that the recovery today is time barred? Can you say that?
No, my lord.
Then
He's saying I should have pinched him earlier.
yes.
That is what
So you show that you have pinched him.
yes. I'll come back now next
Monday?
Thursday. Monday, my lord, will not be one day, my lord, not possible.
Then finish it.
Yes,
Finish
yes, my lord. Specific, आगे कोनो notice.
Learned advocate appearing on behalf of the state respondents seeks further time to take instructions.
It is also.
No, this is not similar. Here, my lord, no appeal has been filed. That is my instruction. No, that is my instruction.
And about recovery notice, that is his point.
My
Same
lord,
thing.
if there is no appeal, my lord, today,
Then also
he has
recovery-
pleaded there is an appeal pending, sub judice. He has said that appeal is whether writ petition is maintainable.
This become 20. Other.
Because the same officer has written in one, my lord, there is no appeal preferred. আরে কোথায় পরেরটা কোথায় সব কপিটা বার করুন ওখানে কথা বলতে আমরা প্রচুর
It shows there is an appeal.
Yes, sir. But whether when this appeal connected with there will be many appeal by the same
No,
person.
whether it's the number,
Which number?
the number.
Because this is my instruction. This specific same officer has written, madam. Same officer. I checked it. I was also surprised.
Then you file a short affidavit on this because this has to be taken on because if you say that appeal has not
Then
been
madam,
filed,
do not record any submission. I'll file an affidavit.
bring an affidavit. Yes. File a report in the form of affidavit. That will be easier
Yes,
instead of affidavit reply and all because short
I'll do
matters
report.
we'll get rid of them. लिखे नहीं? Let Hannah. आस्ते आस्ते थोड़ी देर। It is that matter.
two judgments which are not, I have prepared a small compilation for each worksheet because judgments were given in Haywire form. So those I have attached in a single bunch wherein two additional judgments are, which are just take notes. And not double notes. What I have prepared, the written submission is for there are two cases, for two separate written submission for dates are 9 and 10 are together. For the same SSC, two different permissions are for the same issue.
But 10, no order has been passed as yet.
It indicated that 10 will be tagged with this.
No, verbal না এখানে লেখা আছে along with 1513
The period is different, and issue different.
না দিতে হবে না এর পরে দেবেন
This is my written note which I have in the
this you keep you file when 10 is called, otherwise it will be problematic. Separate orders are passed. Because that will go with that file, otherwise both will be in one file, it will be difficult.
I just what are the points I argued. First one was the condition on input tax credit cannot be denied to the recipient cancellation, and the 74 cannot be invoked. Documentary evidence part. Supplier was registered at the time of transaction, and at the end, commission on issue that show cause has been issued with reconsidered bill. These are the points which I have given a brief synopsis. And the judgment version, which was already given, I have with the separate compilation has been acted over. In this version, kindly take the last page 50. This is an interim order of this coordinate bench 50.
Page 50.
Page 50 of the compilation.
Yes.
Because under similar circumstances, an interim order was passed wherein we had drawn against an order only. A state of order only.
Yes.
The kindly take paragraph number 6. 6 one. By placing reliance on a facility ticket board the issue of financial ticket has been prescribed and there should be more authority from buyer on how to get a tax price seller. In case of result of payment of tax price seller, provision shall be made from the seller. However, reversal of credit from buyer shall also be an option available with the revenue to address exceptional situations like missing either closure of business or supplier not having adequate assets. Submitted in the instant case at the relevant point of time. Message that filed its return. No steps have been taken by the respondent to seek recovery of tax pending from the aforesaid message. The board and winner of the failure of the petition number 1 is absolutely contrary to the law laid down by decision made in Sankara. Sankara by letter lordships in page number 1 of the compilation. One is the Sankara went to Supreme Court and Supreme Court dismissed the SLP on merits as well as on merits. Kindly take there are number 3 on merits and on monetary. I was repeating that. SLP is not a margin. I am not speaking that much. I'm just giving because I have the High Court order. I have attached. High Court. So what merits is added to it, it takes a different color. Having regard to facts and circumstances of the case and the extent of demand being on the level. This is what Supreme Court says. The SLP was not able. Let us not go into that. Page number 3 is our division bench judgment, where the Sankara, the case where the RC was, the cancellation was done.
Yes.
So I have on that point maintained on that point that against the order or a show cause notice also lordship that when in the relevant point of time the supplier was registered. On that point, I just left to do this judgment, nothing more. Otherwise, all the judgments which are direct are already. I just prepared this compilation.
This so I will now refer to this compilation only. I am not going to go anywhere. No, Oryx and Siemens part of your written. You have mentioned the judgments in your notes. No. So I'll go by the notes. That will be safer. Yes, yes. Thank you. That will help.
For the client to expect a rectification from Madhya Pradesh High Court, wherein at the show cause stage, the rate was disputed. The division bench case of the Supreme Court entertained the appeal against that order on the ground only of 70. It was stated in the interim order has been filed also. Yesterday it was been reported, yesterday, that the entire given from any facts of suppression, therefore we stay all the proceedings and but it's nothing. I cannot rely on it because personally indicated at
Not a precedent because Supreme Court or High Court?
Our
Yes.
our division to
Paragraph 9.
this judgment of Calcutta is offered by the first respondent without resorting to paragraph 9. The action in the as before the tax invoices as well as the bank statement is substantial that they have given the price as well as the tax payable thereof. The action of the first respondent has to be granted as arbitrary. Therefore, before this action, and the same the government ought to have taken action. The same either unless or until the first response and out the exceptional case where there has been a collusion between this is one of these exceptional cases where we are seeing I read those paragraphs in the show where we have get collusion. So this falls within the collusions. That's why it's a 70. That's why it's a 74.
You have given me a lot of homework.
And when the civil judgment, I had shown Justice Lalit subsidy. Lalit had prosecuted on the basis that central exception. Here also, my lord, female court did not the situation what will happen when it's a complete court, where every layer of there is multi-layer of adjudication process. Will I hand over the judgment?
No, I have it. This 2020 volume 12.
That was the latest. At their side, they give citation, and my side, I give them compilation.
Serve him with a copy. Serve him soft copy. Soft copy, so immediately you can serve.
No, chartered accountant or 5 juniors, let him deny this. But why not have been inside what common people?
Yes, I also had to face this. Appearing for institutions is definitely a problem in that sense.
Therefore, I have no offense taken on university, I will have that. No, I will not say anything into that. This aspect that complete when you read complete adjudication, tribunal, thereafter appellate authority, then tribunal becoming expected by March, thereafter by the High Court. So this complete process is a multi-year adjudication process. And the fact
You will not file any written note?
I have said,
Why? Mr. Kanodia is filing, you will not file.
5.2 pages. Well, it doesn't have to keep the matter.
No, I'll keep it. What is the problem? Yes.
I have committed.
Same complaint. ওই written নোটটা লিখে নিন।
Initial model process, the judgment was last judgment justice. That was on thesis.
The meeting on 3rd again.
And in return, we final evidence. How it has, when the person was dead, proceedings were started. That one.
Oh, yes. None appears for the petitioner. Full stop. List this matter once again on 8th December.
Regarding pecuniary jurisdiction 2016, limitation was 10 lakhs.
10 lakh.
We are not on the pecuniary jurisdiction, my lord. We are on the subject matter jurisdiction.
So the 2 points my land is passing on the date. The first is, my lord, that the superintendent has no power to adjudicate because 1 lakh.
এটা কি দিয়েছেন দিদি?
হয়ে গেছে শুনকাম।
There was a point with regard to service or something. It was in service.
This is service tax matter. And
What my land says,
for
contended, my lord, he is.
It is recorded in the last order, whatever was argued.
that is very well written.
All the points I had recorded so
Yes,
that
my lord.
it's easier for taking is the there were several contentions, one of which was taxability of security services, and it says that the liability of tax will be on the recipient of services, not on the provider of
The
services.
foremost challenge was on the ground that they lack the territorial jurisdiction. And second challenge was that they lack the subject matter jurisdiction. Because and superintendent is excluded from adjudicating any matter which involves extended period of time.
Yes.
And he is
It's
not
there,
answering
recorded
to
there.
that, but he is talking of the monetary limitation, my lord.
Page 2 of the order. Petitioner's case is one that involves extended period.
Yes, my lord.
In view of the notification dated such as superintendent could not have exercised jurisdiction.
That extended period that has been dealt in the order itself, my lord. The lordship
Where?
takes up. Thank you, my lord.
Oh, the thing.
Yes, 36. Lordship takes up, my lord.
Page?
Page 36. The Foucault itself, my lord, sorry.
उसमें subject ठीक है, उसमें वो ये करा सेट हो जाएगा, इसमें तो वो कह रहा है कि डिफरेंस है दोनों में, ठीक है।
So far, if your document takes up at page 29.
Page?
Page 29.
ये सब वो है डिफरेंस।
Page 29.
Point number 5. Reason for extension of time.
This is reason for extension of time.
Then, my lord,
He says that if whenever extension of time is involved, it is not the superintendent, it has to be somebody else.
Yes,
That
my
is his submission.
Yes, my lord.
He is not on the validity or the genuineness of the reasons. You may have good reasons to extend time, but if you have extended time, then it will not go before the superintendent. It will go before some other higher authority. Superintendent will be only if it is within time. The moment you extend time, the jurisdiction goes out of the hands of superintendent. That is
Yes, my lord. That is exactly my case.
superintendent will have jurisdiction only if the time is as prescribed. The moment you extend, it is out of his hands.
Jurisdiction.
Yes, that was his submission. It's recorded in the order. I recorded with the it with the clarity with which I put.
That point, my lord, I missed. In fact, my lord, I thought, my lord, the jurisdiction of
All the
pecuniary.
points are there, Mr. Chakravarti, Mr.
Yes, yes,
Bhattacharya.
my lord, it is there, my lord. Yeah, I missed that.
All the points. If you read the order, you will get all the
Yes,
points.
correct,
I
correct.
may not be very clear, but it's there.
My lord is very clear, my lord.
And
But this is my mistake, my lord.
and even the other circular that he is quoting, that keeps this exclusion intact. Paragraph page 2, paragraph 2.
So time was taken again. Every time it doesn't look good. You please come prepared so that I can finish this off.
My lord, one thing, my lord, what my understanding referring to your lordship regarding the jurisdiction of the, my lord, the superintendent on the last occasion. Two questions my learned friend raises. One is, my lord, pecuniary, another is territorial.
Please read the order. All the questions are there. Why are you going here and there? The order, paragraph 4 has recorded whatever he had submitted. Number 1 is pecuniary 1 lakh.
Yes, pecuniary, my lord, I have got a notification.
Next, it is 1 lakh only if it is
within time,
not within extended, not yes, if it is not falling within the extended period. If it is within time, only then 1 lakh. If it is beyond 1 lakh and it is extended, it goes out of the hands.
Initially, there were two limitations, or maybe more limitations. One was subject matter, that if period is extended, they will not invoke. Superintendent will not invoke. And even when he will invoke, his monetary jurisdiction will be limited to 1. What my learned friend is submitting today by citing another circular that has only extended the monetary limit from 1 lakh to 10 lakh. But that excludes.
No, for the purpose of 1 lakh, he will have jurisdiction even in extended cases.
Maybe no, because
No,
this
but
is
that was the submission I have
no,
recorded.
maybe, but the order doesn't, circular doesn't say, because this entire circular was handed over last time, my lord. ही अपना के सब दिए छी,
Except in cases of respect.
सब दिए छी.
Very well, very well. Yes.
Yes, my lord.
There are two exceptions. Now I recall it's there. First, page 2. He will superintendent's pecuniary jurisdiction is 1 lakh, and this 1 lakh also is in respect of cases other than those which are related to taxability of services and where the valuation of service and cases involving extended period.
This is super restriction, my lord.
Your case is falling within these two exceptions. The superintendent has invoked power in respect of extended period. And his next point was that the tax incidence should be on the recipient, not on the provider. He says that he is providing it. Why should he be taxed?
With the tax.
Yes. So these are points.
And the very first point was about territorial jurisdiction, because I am
Yes, that is also there.
I am an assessee under Sonic
Badabazar-
Vidhan Nagar.
Badabazar, it was Badabazar. That is
that is
regarding territorial, I can give the answer. Well, regarding the monetary limit also 2010 circular, thereafter 2016.
No, that is not there. Monetary is not a question at all.
Only
He says
extended period.
Extended period. Monetary is not a question because he is not questioning it on the ground of monetary limits or pecuniary limits. He is saying that a superintendent will have jurisdiction only in respect of cases falling within the bracket of 1 lakh, but those cases also which fall within the bracket of 1 lakh will come within the ambit of the superintendent only if they are not falling within the extended period. His case is falling within extended period. So even if it is 50,000
I will go out.
Since it is within extended period, the superintendent will not have jurisdiction. That is his argument.
Correct. Well, I missed this point, but I will come back. One day I shall come.
Don't miss any point. There are all 4-5 points, because you miss one, he will charge with saying that yes, this point is, there is no
And
answer.
one point which
All points
Well,
please
regarding
deal with.
territorial jurisdiction, I am saying, well, both are within the North
All the points, please deal with them. One is Bidhan Nagar Barabazar, another is territorial, another is this extended period, another is clubbing of years.
subjects of order.
Third point, fourth point is there.
clubbing of point is their decision of the, I have got the decision.
Very well.
I
And
write the
fourth
guideline.
point is this incidence of tax,
Yes, who is
recipient or provider.
Remember, even in a case when provider is not paying, recipient is liable to that judgment also. I got.
Hey, please bring everything.
I shall bring my
Other point is limitation under section 73(4)(b). Like it is noted in the order. If my learned friend goes through the order, he will get all the points.
One year, but it was extended by 5 years.
73(4)(b).
Where
is
is
there.
5 years?
My lord,
Where is 5 years?
2010, my lord, held good. Then, my lord, it will go. Because it is extended period, the superintendent has, my lord,
Please see the order and then come. When should I keep it? Because
next Wednesday, my lord.
next Wednesday means third. Third will be lot of matters.
If it is
Third or fourth.
ডায়েরিটা দেখুন কবে আসে, থার্ড ফোর্থ কবে, ডায়েরিটা একটু দেখে নিন, কারণ খুব সব
They mentioned it in the earlier slide. Listed matter, qualification of interim order, item number 1.
This matter is appearing at my instance, my lord.
And I'm appearing, my lord, I'm leading Mr. Gupta, my lord.
My lord, I just want to point out one thing, my lord, whether lordship has jurisdiction
Yes,
to
yes.
take up the matter, because I tell you, lordship, first, my lord, they filed the matter before, I'm placing 3 orders before your lordship. Ekটু দিয়ে দেবেন না. First, the matter was placed before, my lord, the residuary having, my lord, the revenue jurisdiction. Then went to, my lord, first order lordship sees first order before the Malad Justice Basu Chaudhuri having revenue jurisdiction.
Yes.
Then went to Malad Justice Basu having jurisdiction under PPI. It was released. Then went to residuary and residuary passed the order. Malad, as an officer of the court, it's my duty to point it out before your lordship that according to their contention, the matter should be Malad placed and heard before the bench having residuary jurisdiction. So, my lord, 26 June released order from revenue, was 11th August released from my lord.
Yes.
I don't know, my lord.
Yes, sir.
My lord, your lordship has determination to hear hearing matters irrespective of classification.
But affidavits have not been
No, but the directions for affidavits have been already given in the
My lord,
order.
my lord, we are opposing, my lord, we have also sought for this to be listed to be heard out. Now, my lord, if it's the first orders have been passed for directions, my lord, and then obviously when the matter is to be listed for hearing. Now, if my learned friend has not filed his opposition, that does not take away the order that it becomes a matter ready for hearing. So, my lord, that is why we came before your lordship, my lord.
Mr. Ray, the order which was passed on 14th August 2025,
My lord.
by which affidavit this affidavit is not doesn't appear to be in the nature of an affidavit in opposition.
Yes.
It only says directs the respondents to prepare and circulate an affidavit disclosing the figures and dates of the rents paid and enhancement of rent. It's not an affidavit dealing with the allegations or the averments in the writ petition.
My lord, I'm absolutely, my lord, I bow down to your lordship, but my lord will kindly appreciate that was the first direction given to my learned friends. They have not sought to give anything else.
Mr. Rai, the problem is, you know well, after the Supreme Court judgment in Garden Reach, any order that I pass without there being clarity
No,
of
that
the
will become a nullity, my lord.
determination
Yes,
will be a nullity.
absolutely, my lord.
It will be a nullity. So it will be a wasteful exercise because this needs to be clarified. This prima facie doesn't appear to be a hearing matter because it has to be exchange of affidavit in opposition and reply in terms of the rules for it to be heard as a hearing matter. At the
I will be more than happy to argue this matter before your lordship, but this is the issue, and as an officer of court, it's my duty to point it out before your lordship.
Then my lord will kindly direct that the file be placed before the regular residuary bench, my lord. Then that would be better, because if your lordship is going to release it, my lord, then again I have to get it assigned.
No, release means it will not be released on that ground. It will be released on the ground of lack of determination, because hearing it doesn't appear to be. I'll record that and release.
But if your lordship uses the word release, then I will have to get it assigned. Well, what I can do is, my lord does not take it up, then I can, your lordship will say if it could go out of the list, then I'll get it mentioned in the residuary bench and get it there. I think that is a better option, my lord. Because if it gets released, then again it's going to go, my lord.
Assignment will be, I understand.
But only with my learned seniors leave.
Yes,
my lord,
yes,
only
yes.
thing, my lord, tomorrow is the last date for the interim order. So we'll have to mention it at 3 p.m. before the regular bench. Could I? Yes, that's the only.
Grateful, my lord, very grateful.
Let this matter go out of list with liberty to mention before the appropriate bench having determination.
Lord, grateful.
Very grateful, my lord, very grateful.
অন্য মামলা চলবে তো তখন এটা সার্ভার করে আমাকে সই করিয়ে
Grateful, I'm so grateful.
Grateful, man.
Very grateful, my lord, very grateful.
You'll get it on the server right away.
Much obliged.
In this matter, I am for the petitioner, my lord. Yesterday I mentioned before lordship appeared before trial court for the respondent. He is now having the brief.
এটা একটা শুধু রেকর্ড
I know.
This matter stands released from this.
One thing, subject to lordship pressure, Maharaj. They did not file any opposition in the matter. Direction was there. Maharaj, give.
I have released it. I cannot pass any order.
I appear on behalf of the great petitioner that the assessment of stamp duty.
Lordship, I am for state led by Mr. Arun Banerjee. Lordship, I am prayer for only pass over, Lordship, because Mr. Banerjee is appearing now on division bench. He is coming, Lordship.
Passing
He's
it
coming. Lordship, kindly give it pass.
Pass to.
Item number 4.
My lord, a similar matter emanating from the same show cause notice and order has also been challenged and has been kept on Monday,
In this matter, my lord, Mr. Arjit Chakraborty advocate is appearing, my lord. But he is in another court, my lord. My lord. On his behalf, my lord, may I pray for an accommodation today, my lord.
Let it be taken up on Monday along with that matter,
My lord, Monday, my lord, I am informed Mr. Chakraborty will not be available.
We pray for an adjournment on that day. I'll grant it.
My lord.
Not today.
Item number 5.
In single 5 minute, learned senior Mr. Majumdar is appearing. My lord, kindly grant a short pass. He's just on the way. Single
Passed over.
Grateful.
Item number 6.
I am for the rest.
I appear for the petition. May I very shortly place the facts. The petitioner before lordship is a works contractor. Stop. My lord.
Yes.
My lord, the petitioner before your lordship is a works contractor. Now, my lord, before coming of the GST regime, the petitioner was executing works contract and therefore, my lord, discharging service tax liability and VAT liability under the West Bengal VAT Act 2003 as and when the liability arose. Now, my lord, lordship knows, my lord, that in executing works contract, there may be two type of tax which I am liable to discharge. One is the service tax on receipt of the money from the customer. The other is VAT. Now, my lord, in this specific case, there was no VAT on mobilization advance, because mobilization advance, the nature of mobilization advance is an advance or deposit, which is taken from my customer as expenses, preliminary collected from the customer as a preliminary expenses on which there is no VAT. Now, what has happened in this case, my lord, prior to coming of the VAT, from time to time, I have been discharging my service tax liability, and therefore, as an immediate a consequence, I was becoming eligible to claim service tax credit. Now, my lord, what has happened in this case, and that is very important, it's a vested right. It's a consummated and a vested right into the petitioner. Now, there was a change of regime, as they call it, in 2017. I and the GST, my lord. Then I will place the relevant section, my lord. Section 142. The legislature, being conscious of the change, has brought out transitional provisions.
Preliminary, there is a preliminary objection.
To the maintainability.
Not maintainability. Maintenance, the alternative remedies there.
My lord, I have challenged the validity of this section, my lord.
If that be so, why after the order? Why not at the time of
My lord, no. This objection from
this virus of the section was not considered by any other high court prior to this.
No,
and how is it connected? The virus point also, how it is connected in this matter, that there is no specific reading.
But there's definitely specific credit,
My
my
lord,
lord.
will kindly see the petition.
From
As he's taking a preliminary
My-
point, let me hear him first. Yes.
Yes, yes. My lord, I have complied with your lordship's order, my lord. I have complied with your lordship's order. May I place the affidavit in record? Affidavit of service, my lord.
Attorney General's office.
My lord.
Sir. Because virus is under challenge.
My lord, I have complied with your lordship's direction.
Yes, Mr. Kundal,
My
let
lord,
him
will
argue, take the preliminary point.
my lord will first of all look into the pleadings with regard to the virus. My lord will kindly see from paragraph 57, he comes into section 142. Your petitioner in the next place in the alternative and without prejudice. So virus is under in the alternative without prejudice that the section 142 deals with various situations connected with miscellaneous transitional provision. Clause A of section 142 states that notwithstanding contained in section 12, no tax shall be payable on goods under this act to the extent the tax was leviable on the said goods under the value added tax act of the state. Clause B of 142 states that notwithstanding anything contained in section 13, no tax shall be payable on service under this act to the extent the tax was leviable on the said services under chapter 5. Then it goes on to say what clause C says. Then he says at para 61, going through the various subclause of section 142(11), the very important thing which is required to be mentioned is eligibility to claim benefit of transitional credit under section 142 is a vested right. Your petitioner, being a work contractor exclusively engaged in executing composite works contract, is eligible to enjoy such vested right in terms of clause 6, which entitlement is a jurisdictional issue going to the root of the matter. Your petitioner, at the risk of repetition, to explain the situation differently, states that after coming of GST regime and the repeal of erstwhile indirect tax laws with effect from July 2017, one very important issue which became the subject matter of deliberation was as to what becomes of the input credits accumulated under the various acts of the erstwhile regime. To resolve this issue, GST acts which
It's argumentative.
and he doesn't say, and my lord, see thereafter, there is no
But
specific
Mr. Kundali,
plea.
has this aspect of virus been decided by any other high court
Milord,
as of now?
Milord, then Milord, I
2017 Act. 8 years have passed down the line.
I'll find that out, right?
Challenge, if it has been thrown and upheld, then in that case,
yes,
I may not have to.
I'll find
it's a
that out.
central
But
legislation.
even then, my lord, will see there are no pleadings as
Milord, there I
that he can develop.
but I have
Even if-
specifically stated
here,
Point of law he can develop.
point of law he can develop, no doubt. No doubt.
He has
How
said
is
it
it
Calcutta
connected?
virus.
What has that? What bearing does it
That
have on the order?
he was on. He was going to.
And secondly, there is an order, good or bad. There is an appellate jurisdiction that
The
is
order
there.
invoking the provisions of section 142.
Yes.
Yes.
Yes. Now he says today he has to therefore show that 142 has a bearing on his case. That is the only way this can be
No,
admitted.
but if the order itself has been passed invoking 142, it has a bearing.
Yes. Now he has to show through pleadings that there is a bearing with his case.
That the order itself will reveal. If the order is based on 142 provisions.
Yes.
And he is aggrieved by the order.
No, is he
then
saying he is nowhere saying 142 should not be applied on me?
No,
That 142 is something which is the.
If 142 had not been there,
yes,
the order would have been without basis then.
Kindly
If it is
see,
the basis,
kindly see
therefore
page,
the order goes.
kindly see page 134 once.
134.
Milord,
134 once.
Milord, I am on my legs, Milord. He is arguing on merits, Milord.
No, no, merit ही होता है.
No, he's taking
On
the
the
preliminary
maintainability point. Okay.
104.
My lord, we kindly see 134, the last paragraph. Therefore, may I place it, my lord? Has my lord got it?
Is applicable, yes.
Therefore, it can be concluded. Therefore, it can be concluded that section 142(11)(c) is applicable in cases with respect to
So
transactions.
that is the basis of the order.
No, it continues. Kindly allows me to play. In which VAT and service tax are paid in the pre-GST regime, and on which GST would be leviable to the extent supply is made after appointed date for the recipient who has actually put the tax. In the instant case, the
Not
said
applicable.
notice has been paid service tax on the advance received as per the said statute, for which they have raised invoices on their service receiver along with the component of service tax, but no VAT has been paid or received from their customers on the part of mobilization advance, and therefore this provision do not apply to the instant case. Therefore, I am of the view that the transitional provision under section 142(1)(c) is not applicable in the instant case.
Next paragraph.
Next paragraph.
11B is
Further, so his only challenge is 11C.
Because
and that is not applicable, we are saying.
No, let me develop my case before my lord. Let me develop my case.
Then question is, at this point, if the order specifically says 142(11)(c) is not applicable, one, that is his challenge, that 142(11)(c) is ultra virus.
No. I have never. If my learned friend is canvassing my case, my lord, let me open.
He is not saying reading down.
My lord, I am saying, Lord, I'm in my prayer. I have prayed for reading down of the provision.
He is coming before my lord after this order.
Definitely, because after the order, my lord.
What is the reason? When
my lord, then I will have to. My lord, I rely on the decision of the Supreme Court. An officer under the act, the statute, cannot decide on the validity of the statute.
That is
then what is my where is my learned friend's grievance then?
Question of validity of this section.
Let him conclude. I'll hear you. Yes.
Lord. Now, my lord, as I was submitting, Lord, kindly excuse me, my lord. As I was submitting that before coming of the GST regime, the credit of the tax paid was a vested right. Now it was transitioned under the GST, my lord. Now section 142 came as a transitional provision. May I now place, my lord, section 142? My lord, I will not trouble your lordship with the whole of 142. My lord, lordship kindly comes to my clause, my lord, subsection 11 of section 142. May I place it? Clause A. Notwithstanding anything contained in section 12, no tax shall be payable on goods under this act to the extent the tax was leviable on the said goods under the Value Added Tax Act of the state. Now, my lord, this is not applicable in my case. Clause B. Notwithstanding anything contained in section 13, no tax shall be payable on services under this act to the extent the tax was leviable on the said services under chapter 5 of the Finance Act of 1994. Now, this, I'm sorry, I'm extremely.
Yes.
I'm sorry, my lord. May I place now clause C? That is very relevant, my lord. There's a dichotomy in the section, my lord, for resolving which I have no other place to go but to come before your lordship. Where tax was paid on any supply, both under Value Added Tax Act and under chapter 5 of the Finance Act. Now, my lord, this clause opens with, there is an option where tax was paid on any supply, both under Value Added Tax Act and under chapter 5 of the Finance Act of 94. Then what is the next consequence? Tax shall be leviable under this act, and the taxable person shall be entitled to do credit of value-added tax or service tax paid under the existing law to the extent of supplies made after the appointed date, and such credit shall be calculated in such manner as may be prescribed. Now, I'll subsequently place the relevant rule that is better and more clear, rule 118. But kindly see the subclause C. That is the dichotomy or the legislative, my lord, vagueness. Which the mandate is I have to pay value-added tax and fine service tax. And then tax shall be leviable, definitely tax shall be leviable under this act, and the taxable person shall be entitled to take credit of value-added tax or service tax paid. Now, in my case, my lord, there was no value-added tax payable on mobilization advance. Now, if I have to follow the subsection in strict rigor and vigor, then as a precondition, the clause requires or mandates that value-added tax and finance tax has to be paid, and there is no option. It is not disjunctive, it is conjunctive. And subsequently, tax shall be leviable under this act, and the further consequence is taxable person shall be entitled to credit of value-added tax or service tax paid. Now, my lord, from the very inception, I will place the documents. From the very inception, after receipt of the show cause notice, time and again, we have raised this issue before the adjudicating authority. Now, if I may place the impugned order, it has not been considered, my lord. At length, we have placed, my lord. I will not trouble your lordship with every line of the reply. In fact, I have replied 5 times. Before issuance of the show cause, because spot memo was issued, and subsequent to that, lordship, I will only trouble your lordship with only 2 lines of the reply to the show cause. The reply is at page 111 and at page 112.
When was the order passed, which is impugned?
My lord, the order was passed on 10th of January 25.
And when was this writ petition filed?
My lord, in August 2025.
And what is the time for preferring appeal?
My lord, 3 months.
What is the explanation for
My lord, I have, my lord, subject to my, my lord, may I submit with humility, my lord? I have submitted, given my explanation at paragraphs 97 and 98 at page 77, my lord. In fact, my lord, a staggering demand, my lord. The client was really, my lord, taken aback, and this was a debatable issue, my lord. And then steps were taken at page 77, my lord. Lordship will kindly find 97 to 98 paragraph. My lord, this I cannot shy away from this fact, my lord. There was a time gap, but due to the staggering amount of the demand and this being a debatable issue, my lord. There was a total confusion, my lord.
No, he says, it's in page 77, he says, thereafter the order in original gave rise to a huge liability along with 100% penalty. That's a statutory penalty. And also appropriate interest. Initially being saddled with the aforesaid unforeseen liability, the petitioner was for some time totally confused in the
Well, definitely, my lord, because section 142(11)(c), I will
he
develop.
can't say that his petitioner was thinking of 142(11)(c then.
No, from very inception.
Confusion. Now, these are the techniques which petitions are filed much later when there's no other alternative. They come before my lord to get some orders to ensure that somehow they bypass this and go on appeal after taking the benefit.
This question, my lord,
and the blessings of
this
court.
Lord, this unfortunately.
This is the
question of pure question of law. I have. I have no other place to go, my lord. Yes. It is only your lordship protection, my lord.
At least for 3 months.
My lord, there also, yes. 3 months I couldn't have challenged the validity of the section before the appellate authority. That has also once my friend developed this argument, this has to taken into consideration. The appellate authority cannot decide whether the section is valid, whether it has to be read down. It is only your lordship's domain, my lord.
Yes. Page 111.
My lord. My lord, at page 100.
First show why should I entertain this? You have to develop your argument on the virus first, because that is the only ground on which you can sustain your writ petition. If that goes, the entirety of that will go. Because the order is evidently appealable order. There is an avenue of appeal available to you in the statute. Now you have approached this writ court after expiry of the time prescribed for preferring the statutory appeal. Now the statutory appeal comes with a mandatory precondition of deposit. So you are obviating that also by filing this writ petition. So first you develop your argument on why do you say that the virus of section 142 is amenable to challenge.
Mine. Milord, as I read this section, Milord, on the face of this section, Milord, the clause 142.11a and 142.11b is not applicable. But so far as applicability of clause C is concerned, your lordship sees if the subsection is this clause of subsection 11 is kept totally untouched, then Milord, I have to pay the section statutory requires that I have to discharge service tax liability and VAT liability. Then only I become eligible to take claim, take credit. Now in this connection, if I may place, 118, rule 118, then I think, Milord, subject to correction, I will be able to make myself clear, Milord.
Rule 118.
My lord.
118.
My lord. My lord, this rule, apropos section 142.11c, my lord, it says declaration to be made under clause C of subsection 11 of section 142. Every person to whom the provision of clause C of subsection 11 of section 142 applies shall within the period specified in rule 117 or such further period as extended by the commissioner submit a declaration electronically furnishing the proportion of supply on which value added tax or service tax has been paid before the appointed date. Therefore, my lord, rule in my humble submission, my lord, rule 118 definitely carves out an avenue that in a case where either of the tax is not payable, then in the absence of that, I can take credit of the others. But, my lord, now coming back to clause C of 142.11, that mandatorily requires that value added tax and service tax both are, because 111C is I am a works contractor, therefore it is only clause C of 142.11 which applies to me. But if I have to take the protection of that section or claim the benefit of that section, my lord, then as a precondition, I have to pay value added tax and service tax. And then only, my lord, I will be eligible to take, entitled to the credit or value added tax. But here there is again an option, value added tax or service tax. So the later part of the same clause cannot be reconciled with the earlier portion which is mandatory, whereas there is no option. And the moment the show cause was issued or even the spot memo was issued with the allegation that I have irregularly availed credit, my reply from day one has been the same, that VAT is not payable on mobilization advance, but at the same time, since I paid service tax coming under clause C of section 142.11, there was nothing wrong for the petitioner to claim credit. Now, if your lordship kindly takes the impugned order.
Where has this appointed day been defined?
My lord?
Appointed day, where has that been defined?
Appointed.
The expression which has been used in 142.11c.
My lord.
Where is this expression defined, appointed day?
My lord, lordship will kindly find in section 2, subsection 10, clause 10.
210.
10.
Appointed day.
My lord.
Very well. So you are not being doubly charged
No.
You are being given credit for what you had paid earlier. What is
No,
wrong with this?
no, it's subject to correction. They are saying I have already availed of the credit, but they are saying
Subsection C says where tax was paid,
my lord,
on any supply both under the VAT and under section and chapter 5 of Finance Act, tax shall be leviable under this act, and the taxable person shall be entitled to take credit of VAT or Service Act paid under the existing law,
my lord,
to the extent of supplies made after the appointed date.
my lord, subject to correction, that is the issue. I have availed the
Your
credit,
liability,
my lord,
to pay under this act will arise only after the appointed day.
my lord.
So after the appointed day under this act, you will pay the taxes. And after the appointed day, if you have paid any VAT or taxes on the supplies under the existing act, that is before the act prior to this, then you will be entitled to get credit of that.
No,
so
my
there
lord.
is an extra payment from
Subject to correction. Subject to correction. My lord. Before the appointed date, my liability arose, but which work was executed after the coming of the appointed date. I have availed the on my own. The petitioner availed the service tax credit, but the case of the department is that you have irregularly.
But for that may be an erroneous decision at best. But for that, how can you dispute the validity of the section?
Because
how can you say that the section itself is constitutionally invalid?
No, I am not saying that it is totally.
Iris is that.
Yes, my lord. I am not saying in my prayer.
C also.
My lord.
11C is also virus challenging the virus of 142.11C is in fact saying that it is constitutionally invalid.
My lord, I have, although my lord, I have used the expression virus. What I am specifically praying for your lordship's intervention to read down or reconcile this section. In my prayer also I have asked for the same prayer for reading down, because unless and until, in my very humble submission, my lord, the first portion of clause C is reconciled with the later portion of clause C, which is already there in rule 118. Rule 118, because rule 118 there's a option given to the
rule provides the mechanism for working out the section.
My lord.
If the section has been worked out in a particular way that is not pinching the SSE, then why should it be read down also?
My lord, why this pinching the SSE? Your lordship will.
But you said that rule 118 is proper.
Yes.
If rule 118 properly works out section 142.11C. Then I don't find any requirement of reading it down as well.
My lord, see, if you lordship, rule 118 uses the language for submit a declaration on which value-added tax or service tax was paid. So therefore, my lord, the rule subservient to this section provides an option that you take credit of VAT and service tax, whichever is paid. But section 142 clause C says that, in my humble reading, my lord, that VAT tax on any supply both under VAT and service tax is paid, then consequentially the SSE is entitled to credit of value-added tax or service tax. In my case, my lord, subject to repetition, my lord, I have availed the credit. But when it came to the knowledge of the department is saying, no, you have wrongfully availed, irregularly, they are using that, irregularly availed the credit. Because they are saying you have not paid VAT on mobilization advance. Department is saying that 111B is applicable. If your lordship kindly sees, if I now place the impugned order. The impugned order starts at page 120. And the relevant portion is at page, my lord. It starts with 133, my lord. My lord.
Yes.
5 submissions, my lord, I have placed, I have given to the department. Only gist of that submission is reproduced. Why 142.11C is not applicable in my case, which I have replied. Although one may say, my lord, that it is my case that the department officer of the department is not in a position to see whether this section, because they are subservient. This is the 133.
They have dealt with it. They say that according to them, it's not applicable. They have given an opinion. They may be wrong in their opinion.
They have
For
given
that,
a conclusion.
The appellate authority is there to correct it.
Your Lordship, but I cannot, the appellate authority will not be in a position to say that in the face of the clause subsection C, which mandates that I pay service tax and VAT both.
No, it also says in the manner prescribed. The rules now lay down how you are to do it.
That, but
prescribed means prescribed by the rules. Rules have prescribed that.
But subject to correction, my lord, either the petitioner or the department has to circumvent the section and
Not required. They'll go in accordance with the rules because the section says it will be done in the manner prescribed. The rule prescribes the manner. The manner prescribed by the rules is followed by the authority. Where is the problem? It's a straight line now. All the points now are joined.
But
there is no link missing.
But my lordship, kindly see the declaration that I submit. The authority will only go for processing of the declaration once they find that I have complied with clause C of 142(11).
Show me.
My lord.
No, apni push.
Lordship, Rule 118 opens with the opening portion of Rule 118, my lord.
Rule 118.
My lord. Lord, sorry, my lord, I am troubling your lordship. That same rule again and again.
No trouble, it's my duty. Yes. 118.
My lord. Every person to whom the provision of clause C of subsection 11 of 142 applies. Therefore, my lord, in a case where clause C applies, then once a declaration is filed, furnishing the proportion of supply on which value-added tax was paid, and the input, then the mechanism will set in. Then the mechanism will set in. In my humble submission, my lord, looking at it from another angle, Rule 118 cannot be read bereft of section 142.
No, it is within section.
My lord.
It is a declaration to be made in terms of.
My lord.
It doesn't say it has to be read bereft of. It is in consonance with.
My lord.
It is a product of that.
My lord. It's a further step to section 142. 11.
Section 142 is working out itself in this manner.
My lord.
Rather 142 11C.
My lord.
118 is specific to 11C.
My lord.
Of 142.
I'm grateful. So therefore, my lord, again I am repeating, my lord, that is the reason, that is the reason assigned, because the officer has to follow the mandate of the act. The officer has no other option.
That can be a
No, because the officer cannot interpret the law.
No, but I still can't understand why this is problematic for you in the context of a works contract. What has happened? Tell me now.
My lord, in the case of a works contract, I am giving supply, raising running account bills. The customer of mine is giving to me the service tax component. I am depositing. But on mobilization advance, this is the only case, because there may be other VATable items also. But on mobilization advance, there is no VAT. Once there is no VAT, I am not liable to pay VAT. But the section mandates now come. I am transposing the facts of my case to the section. When the statutory requirement is needed to be complied, my lord, then it says that in the first place, VAT tax was paid on any supply both under VAT Act and under Finance Act 1994. Therefore, the first stage is, my lord, tax was paid both under VAT Act and Service Tax Act. Then the next we come to the next stage. Tax shall be leviable under this act. Nobody is disputing that. And taxable person shall be entitled to credit of value-added tax. Then there is an option given to the taxpayer or the petitioner to take credit of value-added tax or service tax paid. First is the compulsion, second is the relaxation. But unless and until I comply with the strict mandate, I do not, in my humble reading of this section, my lord, I do not become eligible to claim the benefit of the relaxation. I have already availed it. It is not a case that I have, my lord, just
I couldn't get you. If you have availed it, why do you want to avail it again?
No, I am not availing it again.
You said I have already availed it.
No, I have availed it. But the complaint of the department is that you have irregularly availed it, going by the mandate of this clause. Irregularly availed it. Now, if the case, some my lord kindly takes it, I never went to appeal. I never came to before this honorable court. Then I become liable to pay the.
What happened in your case?
My case is the show cause spot memo was issued.
No. What is the fact of your case?
My case is
how has your works contract worked itself?
Milord, my works contract had worked this way, Milord, this fashion, that as and when service tax was paid, service tax leviable, I raised the bill on the customer remitted the tax, I paid the tax, and instantly I became eligible to take credit.
So in your case, what has happened? In your case, the services have been taken prior to the this appointed day or after the appointed day? That is the cutoff date.
After the appointed.
So what happens? What is the problem now? What does
now?
It say?
Now the case of the department is says is that
it says to the extent of supplies made after the appointed day, you will be entitled to take credit only upon payment.
My lord.
Then where is the problem?
No.
Yes.
My lord, this is an ongoing contract. This is an ongoing contract.
Yes, even then,
my lord,
ongoing contract, there will be a portion of supplies made prior to the appointed day. There will be a portion of supplies made after the appointed
my
day.
lord.
So there is a cutoff date, appointed day. So whatever you have been supplied with after the appointed day, on that quantum,
I am eligible
to follow.
I have to take. I became eligible to take the credit of the tax paid.
Yes, only upon payment being made by you.
Yes, I have made the payment.
Pay and take it.
Pay and take it. Yes,
so
I have made the payment. But the case is that you have wrongly taken the tax is paid. But I am saying that 100 clause C, being a works contractor, is applicable to me. I am also saying that on mobilization advance, VAT is not payable. But the department is saying, or the legislative mandate is, you pay both service tax and VAT tax paid, and then you take credit.
Yes.
That I have done. But department subsequently is saying that you have irregularly taken the credit. And you return it.
That is an error of jurisdiction, error within jurisdiction.
Because but my lord, if subject to correction
for appeal,
subject to correction, my lord, if the section itself stands, if the section, my lord, subject to correction, if the section stands in the statute as it is, the department is liable to or is eligible to apply the conditions of the section.
So even applying the conditions of this section, where are you suffering a loss?
Because
whatever, it's only since this is a transition phase where there are supplies after the appointed day also, after the appointed day also, before the appointed day also, so there can be a mismatch. So to put it straight, legislature has thought it fit to set a mechanism that in cases of supplies, in cases of contracts which are ongoing, there will be supplies, portion of which will be prior to the appointed day, a portion of it will be after the appointed day. So in order that there is parity of taxes, after the appointed day you pay under the old regime because you are an ongoing contractor, and in the new regime you avail the benefit thereof.
There is a problem. Once
it is not that somebody is being unjustly enriched or something is being unlawfully taken away from you.
Now the department is saying that you have erroneously taking that. Because
that may be an erroneous view of the department. That is what I'm saying. What is wrong with the section then?
Because Milord, I may be totally incorrect, Milord, but subject to correction.
Maybe I am unable to understand, but this is my understanding. You tell me where I am understanding wrong.
Milord, it is my difficulty that I am not able to explain to your lordship, Milord.
So you tell me according to your facts, because that will be the best thing to speak of.
My lord, lordship kindly sees the show cause. Kindly takes the show cause. Page 100. So I'm sorry, Milord, page 101.
Yes.
Whereas it appears from the brief facts of the case narrated herein below that such and such falling under the state jurisdiction having such and such has availed 6 lines from the top. In the middle,
Yes.
they have availed irregular transitional credit. They are irregular, and now they are after narrating the facts. Then they say, my lord, ultimately say at page 106.
Yes.
Paragraph 5 in the middle, my lord, at page 106.
Yes.
Therefore, such and such, having their such and such, are hereby called upon to show cause as to why an amount of such and such, being the wrong input tax credit availed and utilized by them, as mentioned, should not be disallowed and recovered. Because the department is applying the provisions of the section, because it is the case of the department that I have irregularly availed the credit. But my answer to that is that I am very much coming under clause C.
That they have disbelieved.
So
if you are coming under clause C and that is your argument, then how can you in the same breath say that clause C is ultra vires? Then there is no provision in the clause which will help you, in the section which will help you.
I have very humbly,
self-destructive argument.
Milord, I very humbly, Milord, I have not asked for your lordships. Milord, kindly come to my prayer at page 80. I am not asked because I cannot, Milord. The other portions of 142 is not applicable to me. I have no, because that is not my case at all. Because there are very many subclauses in section 142, as your lordship has seen.
I have said declaration that section 142(11)(c) is violative of Article 14 of Constitution of India. That is your prayer.
Like clause prayer B also kindly sees, Milord.
No, that is because of your convenience that you are
because
to interpret it in a particular way which is not agreed
because
upon by the authorities.
Because, Milord,
so it's not a question of it being read down or being ultra vires. Then it's a question of interpretation of the section. That the authorities are definitely entitled to interpret it in a particular way. If the authorities go wrong, the court will correct it. But that cannot be a ground to interfere with the.
Because, Milord, I have paid my service tax. It is not a department is also not paid, saying that I have not paid service, because but since I have not paid VAT, so under 142(11)(c), being a works contractor, you should have paid VAT as well as service tax. Then I should have availed the credit. Kindly see, Milord, the impugned order, Milord, for once, Milord, for once. The impugned order starts at page 120.
Page 120.
At 133, the discussion starts with relevant discussion.
So I will have to stop. I have a division bench at.
My lord, I'm so sorry, my lord.
We'll continue with this.
No,